Before the meeting commences, I would like to acknowledge that we are meeting on the land of the Bidjigal and the Gadigal people who occupied the Sydney coast, being the traditional owners. On behalf of the Local Planning Panel, I acknowledge and pay my respects to the elders past and present and the Aboriginal people in attendance today. Good afternoon and welcome to the Randwick Local Planning Panel. I declare the meeting open at 1 p.m. I'm the chair of the panel. My name is Julie Walsh. Also sitting with me are two expert members, Elizabeth Kincaid and Stuart McDonald, and community member Graham Turner. After the commencement of the meeting, all panel members were requested to sign a declaration of interest in relation to each matter on the agenda. I can confirm that all declarations of interest have been received. There were no conflicts declared. Apart from myself. I have a non-significant, non-pecuniary, reasonably perceived interest in item 2, 3 to 4 Landfoy Street, Randwick, as I know one of the objectors, Stephen Lehman, of Stephen Lehman Consulting Proprietary Limited. We're both appointed alternate chairs of the Randwick Local Planning Panel. I've not sat on a panel meeting with Mr. Lehman, and I have no personal or professional relationship with him. And having regard to this, I propose to participate in the consideration and deliberation of that item. Just to check with the other panel members whether there's any change to their declarations that they have no conflicts of interest.
Nothing to declare, Chair.
Mr. Ryan, nothing. Ms. Kincaid.
Nothing to declare.
Thank you. So we have two items in the public meeting today. The first item is 32 Moore Street, Coogee, and the second item is 3 to 4 Landfoist Street, Randwick. In relation to 32 Moore Street, Coogee, I have 4 registered speakers, 3 objectors and 1 applicant. The procedure is that objectors address the panel first, followed by applicants' representatives, and each speaker will be given 3 minutes to address the panel. The panel has been provided with copies of all of the submissions received in response to the public exhibition of the application. Therefore, if you are a person who's made a public submission, there's no need to repeat the points made in those submissions. Speakers should focus on the key matters they wish to understand and consider, including any suggestions about how their concerns should be resolved or could be resolved, sorry. The applicant may wish to comment on issues raised in the council's report, provide a response to proposed conditions and or address any issues raised. Objectives or councillor. After the speakers have addressed the panel, panel members may ask the speakers questions to clarify any matters. Only registered speakers will be allowed to speak and respond to questions from the panel. Any person using defamatory or offensive language may be asked to leave the meeting or the meeting may be adjourned. An audio recording is being made of the meeting and we ask that speakers use the microphone on their device when addressing the panel to ensure that their comments are recorded. The audio recording will be available through Council's website by tomorrow afternoon. After all registered speakers have been heard, the panel will deliberate and vote on each item in a closed session. So I'll then just move to the first matter, which is 30 to 32 Moore Street, Coogee, DA 351/2025. And the first objector I have noted is Bill Tulloch.
Yeah, good afternoon, Chair. Can you hear me?
Yes.
Yeah, thank you, Chair. Good afternoon, panel. My name is Bill.
Oh, sorry. Can I just ask anyone who's not speaking to put themselves on mute? Thank you. Yes, sorry, Mr. Tulloch.
That's okay. Thank you, Chair. Yeah, my name is Bill Tulloch. I'm representing...
Actually, can I just ask you to speak a little bit louder?
Certainly. Yes, Chair, please tell me to speak again louder if you can't hear me properly. Chair, my name is Bill Tulloch. I come from an architectural background. I'm representing 4 immediate neighbours to the subject site, 3 neighbours in Major Street, which is 1A, 2A and 3, and in Moore Street 28. The names of those neighbours are contained within my earlier submissions. I speak against the proposal. I disagree with the assessment report. My client's main ongoing concerns are character, streetscape, visual bulk, solar access and privacy. And I contend, obviously, on the character, streetscape, and visual bulk issues, that I contend that most observers would find the proposed development offensive, jarring, and unsympathetic due to those non-compliances of heights and setbacks. Panel and Chair, the DA relies upon the provisions of the infill affordable housing bonuses, and I'm sure many panel members will know, but perhaps the community member may not, that the Department of Planning Practices note that came out with the affordable housing bonuses state the full extent of the infill affordable housing bonuses may not be achieved on all sites due to site constraints and local impacts. The infill affordable housing bonuses should not be treated as an entitlement. I say this DA obviously falls into that category. I raise with the panel that these issues are being taken in other panels around Sydney, and particularly in Willara, which I was involved in a month or so ago, when a major scheme was refused significantly on these same grounds. Obviously, every DA is assessed on its own merits. However, I raise this matter as it's the most sensitive area in Coogee. Panels are refusing DAs on this ground, but I have two major concerns relating to the height of building and the clause 4.6. I believe that there is false height of building calculation by the applicant and false clause 4.6 variation justifications. And I say that the 4.6 cannot be relied upon. Height of building, I'll be brief as I can, panel, but I'm representing 4 neighbours, but I'll go through this as quick as I can. Obviously, you need to think through that clause 4.6, and I think it cannot be relied upon. The survey fails to identify the lowest level of the existing building. Heights identified within the 4.6 clearly must be guesswork. I refer you to the Registered Surveyor's LTS survey of 2020. It shows the existing building is built on a plinth above garaging, but there is no definition of the lowest floor of the garaging. The survey fails to identify the lowest levels. But what do we know? Well, the spot levels outside the garage with the existing parapet.
Actually, sorry, just can you stop there? I'm going to give this speaker another 3 minutes because he's representing 4.
Thank you, Chair.
Thank you.
Thank you, Chair. I will be brief. I'm going through it. I've got bullet points to follow, so I will be quick. The existing height of the existing building is 9.7 metres, so it already slightly exceeds the LEP height. My contention is the existing built form already is at the maximum height that is comparable with the neighbouring dwellings, my clients, that face the proposed development. A more likely consideration on height, considering the proposed roof, the spot level outside the garages, which most probably continues into the garage zone, is that the height of building is at maybe around 14.4 metres, but that's not what the 4.6 or the assessment report suggests. They suggest that it's a metre lower at 13.4 metres. But I contend that it's not only at a higher level, but it's far more extensive than the diagrams that are shown within the 4.6. You will understand that the affordable housing bonus gives an applicant up to 12.3 metres, but again, the proposed development is 2 metres higher and far more extensive in non-compliance than even the affordable housing bonus allows. The LEP, nevertheless, is back at the 9.5 metres, 5 metres below where this proposed development is. And obviously, my neighbours' properties are all around about the 9.5 height characteristics. On FSR, obviously, the 30% bonus pushes up the LEP standard from 0.75 to close to 1. And again, I say that the FSR bonuses are incapable of being delivered on this small sensitive site. Obviously, solar and privacy relates to my client at 28 Moore Street. No shadow diagrams have been provided to the living and study zones in the inner courtyard. I know why, because it would be a devastating loss to the non-compliance of that 14.4 metre high building. That's why they haven't got any. Privacy, there are privacy screens, uncertainty to 28 Moore Street. That is another concern. So Options of going forward. I suggest that the panel consider a refusal based upon insufficient information on survey on the clause point 4.6 and the incomplete solar considerations. I also believe that obviously the full extent of the infill housing bonuses can't be achieved. I consider the height of 14.4 meters is inappropriate in a generally 9.5 meter height zone. It is 2 meter higher than the affordable housing bonus, and it's 5 meter higher than the LEP standard. Setbacks are inappropriate. Obviously, problems in character, streetscape, visual bulk, solar access, and privacy. Now, if a refusal isn't granted, which I believe it should be, additional conditions, the only ones I could think through, is really significant setbacks to the upper levels to wall boundaries to reduce the impact of that non-compliant upper level, and obviously additional privacy devices facing 28 Moore Street. That concludes, Chair. Thank you for that extra time.
Thank you. I'll just check if there are any questions. Did you have any questions?
No, thank you.
Okay, thank you very much. The next speaker is Mark Swain. Is Mark Swain joining us? I might move on to Sean Cleary.
Hello, thank you, panel. Thank you for the opportunity to speak. My name is Sean Cleary, as said, and my family and I reside at Unit 5 to 7 Major Street. We are a street level apartment that is directly opposite 30 to 32 Moore Street. I'm somewhat devastated and distressed that council is recommending approval for this development of a 4-storey building on this site. I support sensible redevelopment, but this approval or proposal, sorry, is well beyond what is reasonable, and its adverse impacts will be harmful and lasting. The previous 3-storey DA for this site was approved by council only after substantial trimming and modification to protect the neighbourhood amenity. And where are those protections now? That proposal was 10.8 in height. What's proposed now is a 4th storey on top of that approved envelope. It exceeds the bonus height allowance, as we've just heard, and is far beyond the LEP 9.5 metre control. This is not incremental change, it's gross overdevelopment. There are scores of reasons, as many of them we've just heard, why this development should not proceed in its current form, and I've detailed many in our written objections, but I'll focus on a key issue here and now, and that is the solar access and warmth to our apartment. The sunlight that enters our living room, our dining room, my home office space, and our balcony will be massively impacted. We have 2 windows and a balcony door that will be directly affected. They are our only source of sunlight to those rooms. So once it is gone, it's gone for good. At this time of year, we have direct sunlight for a mere 3 hours, from about midday to 3 p.m. And that is with the existing 2-storey building that is there today. An additional 2 stories to 4 above that will obliterate sunlight. It will erase those precious hours and reduce them to mere minutes. It will turn a currently bright, sunny living space and dining area where I work daily and where on weekends we entertain our friends and family into a dark, cold, uninviting room, permanently devoid of natural light. It will require a significant increase in electric lighting and gas heating to make our apartment habitable. It will add undue expense and unnecessary climate impact. But this is not my greatest concern. It is the real and harmful impact of having no solar access that it will have on the mental well-being of my wife, my 2 children, and myself. And that cannot be overstated. So I plead with the panel and council to reconsider their recommendation for this 4-storey development, to review neighbours' concerns, and to work with the developer to reconsider the already approved 3-storey application as the most appropriate scheme for this site. Thank you for your time.
Thank you. I'll just check.
Nothing.
Did you have any questions? No, thank you very much.
Okay.
Did Mark Swain join? Well, in that case, I'll move on to Anthony Betros, who's registered to speak for the applicant.
Thank you, Chair. Thank you, panel. I'll try and address the issues as quick as I can. I hope that you received a response to some of the conditions that we provided to the panel regarding.
Yes, we did, yes.
Thank you. I might just go to those first and then address the issues raised by the speakers before me. If I can just share the screen, that would be of assistance if possible, just to demonstrate what that is talking to. And if I'll just try and share that now.
So we've got your one time, I think.
Thank you. Can you see the screen okay?
Yes.
Just in relation to the pool, you can see it's associated with a 2-story apartment. So the owner of the property wants to live here. If you come out of the balcony, you go through the gate and then you step down into this pool area. There's a 1.7 metre high screen along this side that prevents any visual and acoustic impacts to the neighbouring property at number 28 to the west. And that's also shown on the diagram, the western elevation, you can see here. So the bulk of the pool is actually in this area here, and the floor level is here. Then you're walking down into this area. So the pool itself will be unapparent from that western neighbour. Furthermore, you can see the substantial 16 metre rear setback from the boundary. Then there's also a laneway, and then there's the northern property as well, which is significantly lower. So they'd have absolutely no perspective of that pool whatsoever. And just going back to the size of it, you can see it's only a very small pool. It's just a cooling off area, really. So we understood that council did raise it an issue with the RFI. We did provide a detailed response, and we respectfully request that that pool be maintained. The other area more significance to the construction of the built form is the condition that requires the removal of the columns at the rear of the property. And in the view analysis we provided, we made it clear that the columns are not actually in any view line whatsoever from any of the surrounding properties. So the removal of the columns won't actually improve anyone's view. You can see the retention of views to Gordons Bay from each of the units to the west, and also other properties in other locations, including 22 Moore Street, 19 Gordon Avenue. You'd appreciate the expanse of the balconies on the long section, and you could then see the effect of cantileering these areas without the columns would be quite significant. It would probably likely to result in a greater floor slab thickness, and then that would compromise the achievement of the ceiling heights as required, with also long-term structural issues as well. The other issue was the removal of the balustrading for this portion here. And on that upper level, it's associated with a planter here. So if you took it off, you'd have no safety device. We think the balustrade provides a continuous edge to the building, as do the columns as well from an architectural perspective. Just turning to the objectors, this DA has been the subject of a previous DA, as mentioned also. Height has been mentioned in that and referred to as well. Now you'll see on the long section, the built form up here where the height variation is substantially recessed from the northern side and far beyond where the garages protrude. So there is no height variation beyond that stated in the clause 4.6. And again, this has been carefully examined with the use of the survey in the previous DA, and again in the current DA, which has the extra part story. When you see the 3D height plane, it is a very minor breach and it's inconsequential in terms of its impacts. North is to the right of the side of the page here. So if I can just turn to the 3D view from the sun diagrams, which show that all northern solar access to the western neighbours is actually retained, and these are the diagrams here. So this is the subject property with the yellow showing solar access to the subject units. This is the adjoining units to the west at number 28. Council's DCP requires retention of solar access to north-facing windows and private open space areas. The internal courtyard area, which Mr. Tullett referred to, is within here and not an area that is identified by the DCP. So what is from 8 o'clock right through to the whole day, this area is actually unaffected. So they're actually getting more than 3 hours as per the DCP. And I grant there will be some reduction of daylight here, but I don't think compared to the existing situation, it would be so much as warrant refusal, particularly when the height variation is limited to this rear portion here due to the sloping nature of the site. In terms of privacy, that's very well covered by council's conditions and the design. When you look at the western elevation, there is minimal opportunity for west-facing overlooking, and all these areas are suitably addressed by condition, as are the balconies. You can see the planters on the western side that avoid you getting towards those the location of those neighbours. If you have been to the property, and as shown on the 3D view from the Suns as well, you'll see that all these properties more or less overlook each other. This is a pair of semis. There's very little privacy enjoyed amongst the neighbours because they're all got the desire to look at the views.
Your time is up. I'll just let you conclude quickly. Yep.
Thank you. The practice note hasn't made its way into any legislation in terms of it's an automatic entitlement, and I also agree that it isn't. But I'm also involved in that other matter with Wallara with Mr. Tulloch, and I can't say that there's any devastating view loss or devastating loss of solar, which is associated with that other development. So I think there's a clear distinction between the two. Again, happy with the recommendation for approval and happy to answer any questions.
I did. Mr. Petros, can you, while you've got the drawings on the screen, can you just respond to Mr. Cleary's concern at Unit 5 to 7 Major Street regarding overshadowing? Perhaps you could take us to the overshadowing drawings.
Yes, if I could just, that's his property here. Can you see this photo on the screen?
Yes, we've got that.
Thank you. I understood that Mr. Cleary's unit was on the ground floor, whether that be this level or here. So you can sort of see that the relationship of that property.
It's the lower one. So
Thanks. Thank you, Mr. Cleary. Appreciate that.
on the left.
Thank you. So just here. Thank you. That presents as 3 stories to the street, drops away to 4 stories. So it is from a 4-story building. But I can go to those solar diagrams, and you can see the properties across the road. This is 1 o'clock, so they get in view from about here you go here. So you can see it's this area down here, behind here. So it's really between 3 and 4. The 3 to 4 period is the DCP, whereas the ADG is, as you would know, is 9 to 3. So in my opinion, this is the 2 o'clock diagram. There'll probably be some impact between 2 to 3, but from a compliant FSR, and it's across a site, like it's separated by Major Street, which is a substantial distance of separation. Being a single aspect unit to the west, it is probably vulnerable with those overhangs, and also with the vegetation that you saw in the front. It's a highly trafficked area between the coastal walkway, as you'd probably be aware as well. So I don't think the extent of solar access impacts would be significant, in my opinion.
I think so. Thank you.
Did you? No, I didn't have any questions either. Thank you. So I think that completes. Mr. Swain didn't turn up. Okay, well that completes the speakers for that item. As I indicated in my opening, when we've dealt with the next item, we'll go into closed session and make our determination, which will be available on the website in due course. So the next item is 3 to 4 Landfoy Street, Randwick, GA 437 2025. And the first speaker I have is an objector, Christopher Sassone.
Hello, can you hear me okay?
Yes, thank you.
Excellent. So good afternoon, panel members. My name is Chris Sassone, and I live at 5 Albert Street. So this is directly next door to 34 Lane 4th Street. My family moved here from the United States around 10 years ago to be closer to my wife's family. Since then, we've become deeply integrated in the local community. And today I'm speaking on behalf of a neighborhood group of more than 25 households. We've met multiple times, engaged with local council, and worked together on this united objection. I want to be clear, though, we are not anti-development, but we are against developments that are blatantly breach planning controls, damage neighborhood character, and deliver no real community benefit. We also need affordable housing that's built for families right now. They currently have an approved DA, so please build the building that was approved instead of continually changing the scope of work and trying to chase further profit. So I'd like to talk about some of the non-compliance and overdevelopment. This site was originally approved for 4 stories with 2 basements. The new proposal seeks 7 stories plus 2 basements, bringing the total to 9 stories. And these breaches are significant. The height of 31.3 meters against a 22-meter limit, it's a 42% variation. The FSR of 2.42 to 1 compared with the permitted 0.09 to 1 as 167% excess. The applicant's claiming a ground level that is 2 to 3 meters above the current street level to get around these planning controls. They've also misused the affordable housing step. In the original DA, 75% of the apartments were 3-bedroom family units. In this amendment, that drops to just 24%. Affordable housing stays at the bare minimum 10% of gross floor area, despite a 54% increase in dwellings from 11 to 17. This is not about affordable, sustainable housing. Once again, this is about them profiting more. So now from a community impact. This proposal will cause significant overshadowing and loss of winter sunlight to neighboring properties. It creates serious privacy loss from elevated balconies and windows. In fact, the stories added will now look through my upper skylight directly into my bathroom. Parking and traffic impacts will be severe. There are 0 visitor spaces and only 18 spaces for 17 units. And this property is positioned on a narrow cul-de-sac that connects to a narrow one-way street. And once again, the developer is using the Affordable Housing Act to claim less parking per unit to be able to barely fit this in. The community opposition here also is really strong. There's 75 formal objections have been lodged and nearly 400 residents have signed a petition. This is a broad, not isolated opposition. Lastly, let's talk about precedents a little bit. We've seen a pattern here. This developer has secured a modest approval and then escalate height and density through amendments and appeals until the community is either fatigued or runs out of money to fight them. This project has been rejected multiple times by council and yet still continues forward at a greater scope, even using the exceptions from their own previous DAs on these new DAs. This DA should be looked at with complete fresh eyes, no exceptions given. Approving this DA would send a clear signal that the planning rules are negotiable, undermining trust in both the council and the LEP. So in closing, I urge the panel to refuse this DA amendment and to help the community stop the developer from using the LEC courts to bypass council and the community. This is about defending the R3 zoning intent, the integrity of Randwick's planning framework, and the residents' rights to sunlight, privacy, and livable streets. Please stand with us as residents and send a clear message that the Randwick planning rules can't be bypassed solely for profit. Thank you.
Thank you. I'll just check a few minutes, please.
No, thanks.
Thank you, Mr. Sassone. The next speaker is on behalf of the applicant, Hamid Samabi.
Yes. Hi, everyone. Thank you, panel, for the time. I guess there is a broader question here about density, whether we want density in this area or not. So I understand the objector maybe is not aware of the recent rezoning that has happened in the area. So based on the low mid-rise rezoning that government has introduced, so the whole height and FSR of the area has changed. So we are just following that basically. We are working in other, obviously, councils, primarily in the eastern suburbs. So mainly Woollahra Council, Waverley Council, and Randwick Council. The change has been embraced by Woollahra residents and Waverley residents. They're putting properties together and they're celebrating the new opportunity. So The objectors that they're objecting to this development, the value of the property is probably tripled now, just because of this rezoning. So whether they want to fight against this and devalue their property, because that's a precedent for every property in Randwick, that's up to them. What we are doing is, I guess we have an objective to provide housing. And well, you go to Rose Bay, Double Bay, those areas, you see it's buzzing and you see a lot of new developments coming up. Unfortunately, Randwick and Coogee is lacking stock and lacking new properties. So we focus on downsizers, those people that they can't walk up the stairs anymore, they can't use the staircase, they need level access, they need bigger apartments, they need lift, and those people, they want to stay in the area and they need apartments to be built for them. So I guess the objectives are a bit different. I'm happy to answer, but we are just following what government wants to do, which is housing. I understand everyone wants density, but everyone says not in my backyard. That's a different discussion. But in terms of the actual development that we are doing, it's actually one level below the standard height that we were allowed, just because it creates other fire issues and all of that. And also our property is well sort of inside the area that is sort of down the street and is next to a tower. So in terms of character, if one building can be built to this height, that's this site. So we don't know what to answer. I understand if there is other objectives here, I'm happy to answer. But in terms of new rezoning,
so that was a three-minute bell. If you could please conclude.
Yes, I basically answered, yeah, the question.
Did you have any questions?
No, thanks.
Question? No, I didn't have any questions either. Thank you for coming along and addressing us. The next and last speaker I have down is David Sachs, also on behalf of the applicant.
Hi there. Hi, panel and chairman. I believe Hamid expressed a lot of those statements well, and not too much I could add to that.
Oh, okay. Thank you. All right. And Mr. Swain never reappeared from item 1? No. All right. Well, in that case, that concludes all of the registered speakers. In accordance with the panel guidelines adopted at the panel meeting on the 13th of December 2018, the public meeting will now be closed and the panel will deliberate and vote on each matter in a closed session. The outcomes from voting and determination will be made available through Council's website in the following days. An audio recording of the public meeting will also be made available through the Council's website. I declare the meeting closed at 1:35 p.m.